CR 19230. I believe at the last setting, Mr. Ashmore, there was a suggestion of incompetency. And since that date, the court had authorized the evaluation on the basis of competency. And the report that the court received was that Ms. Dean was found to be competent by Dr. Ingram. Is there any challenge to Dr. Ingram's finding at this time?
No, Your Honor.
I'm assuming the state doesn't have a challenge either. Is that correct?
No, Judge.
All right, and so at this point, with Ms. Dean having been found competent, there being no challenge to that, has Ms. Dean and the state exhausted all of their negotiations in this case, Mr. Ashmore?
Unfortunately, I think so.
State, you agree?
Yes, I agree.
All right, so Mr. Ashmore, do you believe that Ms. Dean understands that if the court passes her through docket call and sets for jury selection, that if she later changes her mind and decides that she wants to accept a plea agreement, or even if the state wants to offer a lesser charge, that the court may not entertain that at this time?
I have explained that multiple times to Ms. Dean, and including this morning and going back over recently the two plea offers that have been extended by the state of Texas.
And what are those?
Both of those are Class A misdemeanor probation type plea bargain agreements. So reducing the second degree felony to a Class A misdemeanor with them. They are onerous, but they are a path to freedom probation conditions that include some incarceration time.
Let's go ahead and just put it on the record exactly what it is. Is it straight? Is it deferred? How much?
There's a straight 12 months Van Zandt County Jail Class A misdemeanor deadly conduct offer that was extended in early June.
Probated?
No.
Okay, just straight time?
No, because Ms. Dean requested a straight time offer.
Okay.
And the state complied with that request and offered to reduce the offense to Class A misdemeanor. And then a second Class A misdemeanor with, I believe it was 14 days county jail time, and then the rest of that sentence would be probated. And I can't remember exactly the duration. It was 12 or 18 months.
Any clarification from the state on that second offer?
I believe it was 12 months, Judge. As Mr. Ashmore recited, I made two different offers on a Class A assault, and I just don't think I can do any better than I already have.
Well, he mentioned the 12-month straight time, but then he's indicated that there was some type of probated offer with 14 days in jail as a condition of probation. Is that what I heard correctly?
I believe that's my recollection. I memorialized that in an email to Ms. Dean. I can look for it.
Let me pull it up, Your Honor. Judge, the offers were, there was time on a Class A deadly conduct, and then there was a 1 year probated 12 on a deadly conduct with 10 days in jail as a condition.
One pro 12 with 12 days in jail.
10 days.
10 days in jail. One pro 12 months, 10 days in jail as a condition of probation. And so, Ms. Dean, you are rejecting both of those offers. Is that correct?
Yes, sir.
You're not rejecting those?
Yes.
I think there needs to be more communication between you and Mr. Ashmore regarding whether or not you're going to accept one of those.
Well, I think I can speak for myself.
Well, you can speak for yourself, I'm sure, but you can't speak for yourself in here because you requested a court-appointed attorney, and Mr. Ashmore was appointed to you, and he speaks for you. Okay, so what I want to know is, are you going to accept one of those, or are you rejecting both of those? And while you're thinking about it, if in fact you are charged with aggravated assault with a deadly weapon, which appears to be a second-degree felony, the range of punishment should you be convicted of that offense. That's an if. Should you be, if you are convicted of that offense, the range of punishment that the court or the jury, whoever decides that issue, could put you in prison anywhere from 2 years to 20 years, and also assess a fine up to $10,000. So what I've heard from both the state and from your attorney is that the offer by the state is to remove the possibility of prison in your future. In exchange, they're asking you to plead guilty to a lesser offense of deadly conduct, and have given you a choice of either accepting a 12-month or 365-day sentence in the county jail, or accepting a conviction for deadly conduct, receiving a 12-month sentence in jail, with that sentence being suspended, you being placed on probation for that 1 year period to comply with terms and conditions of probation. And a part of that, one of the terms would be that you would serve 10 days in jail. And it appears to the court that if you accept either one of those, your case would be resolved. If you accepted the probation, then if you complied with every term and condition of your community supervision, then you would serve 10 days in jail, and then you would serve the rest of it in your home and in the community. So what I want to do is, Mr. Ashmore, is this your last case?
No, I have an arraignment on Mr. Robert Yates.
So this is what we're going to do on Ms. Dean. Ms. Dean, I want you to have a seat. I want you to think about that. And then I'm going to let Mr. Ashmore finalize his last couple of cases. And then I want you and him to talk a little bit more before we announce whether or not we're going to reject it, because this is what's going to happen. And I'm not trying to force you to accept something. I just want to make sure that you are clear as to what will happen if you say, I don't want either one of those. And that is certainly your right to do that. But if you reject those and you can't reach an agreement, I want you to have done that with clarity of mind and being fully informed of all the legal possibilities and consequences, because the court would then give you what you would be asking for, which would be a jury trial. And then a jury of your peers would decide, or the court would decide based on your election. And if convicted, I want you to understand that can certainly be on the table for you in your future. Okay, and I don't want there to be any buyer's remorse that had I known, and a lot of times people do that, they look back and think, wow, I could have this done with 10 days in jail and probation, but now I'm looking at 20 years in prison. I don't know the facts of the case. I don't need to know the facts of the case. Mr. Ashmore has that, the state has that. That's not my business at this time, okay? My business is to make sure that you receive your counsel, and I've done that, and that he's representing you, and that he's explaining to you all of the legal nuances regarding what you're looking at on this charge, okay? And I want you to have as much information as you can so that you can make an informed decision, and then that's what we do. You tell me what right you want to invoke, right to a plea bargain, right to ask for a bench trial or a jury trial. And I want you to do that after having weighed all of the circumstances and the facts and making a decision that's best for you. Okay? So go ahead and have a seat, and Mr. Ashmore will be back there with you in just a moment.
Thank you, Judge.
You ready on Mr. Yates?
I am, Your Honor.
CR 20-97, State versus Robert Yates. Mr. Yates is set for arraignment.
He is, Your Honor, and
Has he had a chance to review the indictment?
we're going to do it right now, but he does understand the facts and allegations against him. The state was kind enough to email it over to me this morning. We had some problems getting it off the portal, but as I understand it, our office now has it. Just give me about 10 seconds to review.
Yes, sir.
Judge, while they're going over that, just wanted you to be aware, that Ms. Abney sent over, a blank TRN order to the clerk for them to have that for anybody who might need one.
Okay, thank you. We did get Mr. Gonzalez out over there, so thank you for that. Ms. Adams, if you're still with us, thank you very much. You ready, Mr. Esposito?
We are ready, Your Honor.
Okay, does Mr. Yates waive the formal reading of the indictment?
He does, Your Honor.
And he waives the formal requirements of arraignment?
Yes, he does, Your Honor.
His name is spelled correctly,
Yes, it is, Your Honor.
and he understands what he's charged with
He does, Your Honor.
in his plea at this time?
Not guilty, Your Honor.
Court will enter Mr. Robert Yates' plea of not guilty into the record. We'll set this for pretrial. Set this for pretrial on September 29th, unless you have any scheduling issues, Mr. Ashmore.
No, I think I'm actually here that day already, Your Honor. We appreciate it.
All right, Mr. Yates, once you sign that and you receive the yellow copy, white copy stays with me. After that, I'll need you to report to pretrial release department over here to your left with Ms. Burns here.
Yes, Your Honor.
After that, once you receive information, you'll be free to go. Is Mr. Howell a plea today?
Well, Judge, it was set for a plea, and we had an offer from the state that initially we were in agreement with. And Judge, we've had a chance to talk about that several different occasions. Going over the paperwork today, Mr. Howell indicated that he did not wish to accept their plea offer. Judge, the offer, well, there's a couple of different options. Either he had the offer of 1 year of regular probation, 1 year probated for 1 year with a $1,000 fine, or 2 years of deferred with a $1,000 fine. There are a couple other options regarding the fine, but that really wasn't the issue. It was just a matter of pleading guilty to this charge, even though it's a lesser charge. We've had quite a bit of time to talk about the case and the allegations against him by the alleged victim, and he's indicated that he does not wish to plead guilty even to the lesser included charge and wishes to have a jury trial.
And you believe that he has thoroughly considered his facts and circumstances of the case, and you believe that that's an informed decision?
Yes, sir, I believe it is. We had a chance to talk about, by pleading guilty to the lesser charge, that would not be any admission or confession of impeding breath, as the initial as the indictment states. But regardless of that, even the allegation of causing any kind of bodily injury, he's not in agreement with that, with those allegations. In fact, I was going to put him on the record real quickly about.
All right, Mr. Howell, raise your right hand, please, on the oath. Mr. Howell, you are Denny Thurman Howell, is that correct? That's correct. Mr. Howell, do you swear that the testimony you give to the court today is the truth, the whole truth, and nothing but the truth, so help you God? Sure. All right, go ahead, Mr. Chambers.
Thank you. And Mr. Howell, just briefly, you understand that we were set today to come to court and enter a guilty plea to the lesser included charge of assault and family violence, which is a misdemeanor charge. Is that correct?
That's correct.
All right. And you understood that the state's plea offer was either a year of regular probation or 2 years of deferred adjudication probation.
Correct.
And you understand that the state was reducing the charge from a third-degree felony, family violence, impeding breath allegation to a Class A misdemeanor, assault, family violence, causing bodily injury. And we had a chance to talk about the difference between those two allegations. And if your desire today to reject any plea offer from the state as has been presented at this point and enter plea not guilty and have a jury trial set. You're asking the court to set this case for a jury trial.
Yes, sir.
And you understand too that we talked about the punishment range on a third-degree felony, and you understand what potentially could happen if you are found guilty, whether it's probation or you potentially have 10 years in prison. That's all, Judge.
All right, the court is going to then set Mr. Howell for jury selection beginning October 26th. Mr. Howell, you're to report to the basement of the courthouse on that date. Your case will likely not be set or reached for trial. It'll be set for trial, but will not be reached for trial. You'll receive a notice of setting on that date with a new date. And you'll continue to do that month to month until your case is reached for trial. Okay? Once you sign the notice of setting form, you'll be free to go. Shannon, is that all you have?
It is, Judge, I've been visiting with Mr. Skinner, and I understand that, he was here for arraignment today, so I told him I'd stick around. I haven't been retained yet on his case, but we have talked about, potentially, me representing him. So I was just gonna let the court know that.
Let me review his case again. I believe this is the second time we've had a hearing like this. This is CR 20-65. Today we were set on your case for a status to hire an attorney. Court again reviewed your financials and finds that you do not meet the indigency eligibility for court-appointed counsel based on your finances. This is the second hearing and you've not hired an attorney, is that correct? All right, now Mr. Sanders has indicated to me that you're in discussions with him, and because Mr. Sanders stuck around today to indicate that to the court, I'm going to give you one last reset. Okay, I'm going to reset you to September 15th, and whether you hire Mr. Sanders or someone else, I expect to have an attorney representing you on that date. You're charged with sexual assault of a child. It's 2 to 20. Serious. Whether you're guilty of that or not, it's very serious. Okay? And this is not something you're going to represent yourself on. And you're going to, whatever ability you have to get money, you need to get that, and you need to hire an attorney. You need to be here with that attorney, or the attorney can file a waiver of arraignment on that day. So whatever you got to do not come back into my court on the 15th and tell me that you need more time. This will be the third time. All right, this is our second setting today. I'm going to give you one more. I'm giving you plenty of time. All right, and so you're at that juncture where you got to do what it takes to hire somebody. Okay.
Your Honor.
Yes.
I think Mr. Skinner and Mr. Sanders both need to know if they're going to enter into an attorney-client relationship. The Van Zandt County Grand Jury meets on Friday. The state plans on presenting a case to the grand jury on Mr. Skinner for failure to appear. So I just wanted both Mr. Sanders and Mr. Skinner to know that there may be a new indictment coming down on Friday, because that could have an impact on their agreement for representation. So I just wanted them to be aware of that.
All right, thank you, Mr. So I'm sure Mr. Sanders appreciates that, as does Mr. Skinner. So if you do not hire Mr. Sanders, then you'll need to provide that information to any other attorney that you hire that you're potentially looking at a new indictment for failure to appear. Another felony case, which would affect how much someone's going to charge you to represent you, because they're going to be representing you on more than one case, most likely is what the state's saying. Okay? So on September 15th, I'm going to, can you give me a notice setting? I'm going to fill this out, have you back on September 15th with an attorney. All right, Mr. Skinner, I need you to sign here where it says defendant. I need your address. I need you to date it, and then we're going to give you a yellow copy. You need to see it. After you receive that, you just say that here. All right. Thank you, Mr. Chairman. All right, free to go, Mr. Skinner. September 15th with your lawyer.
Sir.
Mr. Ashmore, Ms. Dean. CR 19230, what say we?
We're gonna ask the court to report to the jail for the 130 docket and enter a plea bargain. The state of Texas is preparing the documents right now.
Yes, sir. All right, we'll see you at 1:30, Ms. Dean.
Thanks, Judge. Maybe excuse me.
Yes, thank you.